Of the regular calendar. The Committee on Municipal and County Government, to which it was referred, House Bill 147, an act relative to homestead exemption amount. Having considered the same, report the same with the following amendment and recommendation that the bill ought to pass with amendment. Representative Susan C. DeLemus for the committee. The amendment is 0119H, printed in House Record 11. On page 197. Are you ready for the question on the amendment? All those in favor of the adoption of the amendment signify by saying aye. Aye. Those opposed, nay. The ayes have it, and the amendment is adopted. The question is on the committee report as amended. Are you ready for the question? All those in favor of adoption of the committee report as amended signify by saying aye. Those opposed, nay. The ayes have it, and the committee report is adopted. The majority of the Committee on Science, Technology, and Energy, to which it was referred, House Bill 153, an act relative to the Telecommunications Planning and Development Advisory Committee. Having considered the same, report the same with the recommendation that the bill ought to pass. Representative Susan Harvey for the majority of the committee. The minority of the committee, having considered the same and being unable to agree with the majority, report the following resolution. Resolved that it is inexpedient to legislate. Representative Michael Vos for the minority of the committee. Are you ready for the question? All those in favor of the adoption of the committee report signify by saying aye. Aye. Those opposed, nay. Nay. The ayes have it, and the committee report is adopted. The Committee on Science, Technology, and Energy, to which it was referred, House Bill 362, an act relative to the reliability of the electric grid. Having considered the same, report the same with the following amendment and the recommendation that the bill ought to pass with amendment. Representative David K. Murtaki for the committee. The amendment is number 0183H, printed in House Record 11 on page 200. Oh, I'm sorry. Representative Kirk is recognized to ask a question. Representative Murtaki will yield to the question. You may inquire.
Thank you, Mr. Speaker. Mr. Speaker, this bill tries to make our electric lines less subject to damage from storms and other things. And my concern is whether or not it inadvertently takes away my private property rights. The first section of the bill, section 1, talks about hazardous trees, and the governing body of a city, of a town, can declare certain trees a nuisance if, under the bill, they represent a danger, and then they can remove the trees from my property, from the public right-of-way, not my property, without compensation or without cost to me, the abutter, and if it's a right-of-way, I may own the land. But when it comes to cutting trees that are not hazardous, then they have to get my consent to cut the trees. And the change here, and I want to make sure I understand it, is that right now the law says they can only cut the trees in the right-of-way, but the amendment says they can cut trees which may fall upon the right-of-way, the tree on my property which may fall on the right-of-way, if it's a danger, no longer unreasonable danger, but just a danger to the reliability of equipment. And if I consent, they'll cut it down at no cost to me. But on lines 18 through 19, it says, if I appeal, and the selectmen say, despite the fact that you don't agree, nonetheless, we think the trees have to be cut, then it seems that not only are my trees being cut, but I have to pay for it. And I don't get compensated for the loss of the trees. So here I am with 3 beautiful maple trees on my property, the power company wants to trim them or take them down because they think they're going to fall and be a danger. And if I don't consent, I've got to pay for it. And in no event do I get compensation for the decrease in the value of my property because my beautiful maple trees are gone. Is that what this bill does?
Yes. Thank you, Representative, for this very, very astute question. It was kind of a long question, so let me attempt to break up my response. First of all, the amendment itself only inserted a missing comma into the original bill. So the original bill, however, addresses the points that you raised. So yes, when I first introduced this bill into Science, Technology, and Energy, I actually attempted to highlight exactly the points that you just made. The current legislation without this bill, much of it was passed in 2008 when this legislature responded to the terrible ice storm of 2008. And it established a couple of new sections of legislation which allowed a public utility or a local government to essentially eyeball dangerous trees that were in the easement, in the public right-of-way, and then identify trees that were that were a danger to basically go ahead and fall on public electric lines. So what the legislation 7 years ago did was essentially to enhance the ability of the utilities to go ahead and identify trees that should be either trimmed or cut in the public easement, notify the owner, and the owner then had a 45-day period in which to go ahead and respond that no, I don't want it. And then if you appealed the decision, or that the tree should be either trimmed or cut, then you had the right to schedule a hearing, a quasi-judicial process, and then argue your point. The bill would go ahead and simplify further the ability of the public utilities or the local governments to identify which trees were dangerous within the easement. But then we get to the most interesting and controversial part of this bill. And the representative is exactly correct, except for one point. The new bill, the fourth change, essentially says that if during this process the tree surgeons that are essentially examining which trees could be a danger in this tree cutting process, if they see a tree that is in the abutting property, yes, this is private property, and if they identify a tree that looks like, hey, you know what, there are no other trees, if this thing falls and it looks like it's going to fall because it's dead or that branch is dead, and there are no other trees around it to block it when it falls to take down a power line, we can then identify that tree on private property as a candidate for removal. This is a change. Previously, the trees that were addressed were on the easement. The easement is still private property, but there's a public right-of-way. What we're talking about is the abutting private property that is not in the easement. So this bill would actually provide a mechanism whereby the utilities could go ahead and identify a candidate that is on your property, not on your easement, for removal or trimming. Now, the wording in the legislation does not change the other part of the existing legislation, which is to trim or cut or whatever you're going to do with that tree at no cost to the owner, but with no compensation. So I'm not sure you said what maybe you meant to say. This does not cost you anything to take the tree down, but if the removal of that branch or the pruning or even the cutting of that tree reduces your property value or your perceived value, this current bill in its current form does not provide for any additional compensation for that loss. Does that answer your question? Representative?
It's not the answer I wanted to hear, but I agree it's an accurate answer. Thank you.
Okay.
Does the member yield to a further question?
Oh, certainly.
Representative Itzi, you may inquire.
Thank you, Mr. Speaker. Thank you, the member, for taking my question. There was an unanswered question that for the representative from Ware asked that was not answered. If you appeal, do you have to pay for the removal of the tree? And then I guess more importantly, do you get to keep the wood?
Thank you, Representative, for the question. I'll answer the second part first. Yes, under the previous legislation and under the current legislation, you do get to keep the wood. If during the appeal process, if you are unsuccessful in the appeal and the utility goes ahead and prunes or cuts the tree because it constitutes a danger, once again, the current bill says it is at no cost to you, but at no further compensation to you. However, neither the existing legislation nor the legislation as amended would prevent the abutter from essentially negotiating something else during the quasi-judicial process. Does that answer the question? Okay, thank you.
No, you have not. Thank you. The question is on Amendment 0183H. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it, and the amendment is adopted. The question is on the committee report on House Bill 362 as amended. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. No. The ayes have it, and the committee report is adopted. Chair recognizes Representative Horn for a motion. That does complete the regular calendar.
Mr. Speaker, thank you for taking my motion. I'd like to make a motion to reconsider HB 269.
Member's motion is recognized. Would you like to speak to your motion? All right. Chair recognizes Representative Rowe to speak against the motion. Representative Baldessaro? Representative Baldessaro is recognized to speak in favor of the motion.
Thank you, Mr. Speaker. Thank you, Representative, for listening. I'm going to be real quick on this here. We were asking to reconsider this bill, and for many reasons. And as an old property owner who was forced to sell my property because of people not paying rents and trying to get into court and get them out of there because of failure to pay rents, and then the damages that are taking, we owe it to not only our constituents, but we also owe it to the people that invested their hard-earned money in their property to buy rental properties for the future of their family. This is an opportunity for us to do the right thing because many other states have this. I'm so glad that when I had my property in North Carolina, my rental properties, I invested in that property for my family, only to have renters take it away when they weren't happy. So this is why this bill is in the best interest not only for the property owner, but also for the renters there to ensure when they move out in a year, 12 months from their lease, at least that last month, they don't have to struggle to pay the rent. They use that money to move on to another place. This is a no-brainer. So I'm asking you to support this reconsideration. Thank you.
Chair recognizes Representative Rowe to speak against the reconsideration motion.
Thank you, Mr. Speaker. When the House Judiciary Committee received this bill, we gave a great deal of thought to the rights of the tenant and the rights of the landlord, and the consequences that there may be to the state of New Hampshire. We recognize that that this can cause additional cost to the landlord. Yes. Well, let me strike that in saying, having sat on many landlord and tenant cases in court and the resulting small claims cases in court, one thing that I recognized was the fact that the landlord has rights, but after all, didn't the landlord choose the tenant? It's like complaining after a divorce that you divorced your wife. Well, you chose her in the first place. We felt the balance in this case. It was a balance between the rights of the landlord and the risk and the rights of the tenant. And we feel we did the right thing by saying no. A landlord can, in fact, ask for 3 months' rent, 6 months' rent. But what we really are dealing with here is those very few tenants that move out at the end of the last month and hadn't paid the last month, and they expect the landlord to use the security deposit for that month. I don't think under the law you can do that. So I feel that asking for a security deposit and 2 months' rent is an unreasonable application of the law. We felt this is in the best balance between the state, landlords, and tenants, and I would hope that you would support the Judiciary Committee decision and push the red button or say no.
The parliamentary situation is that a member who has voted on the prevailing side on a bill has the right to move to reconsider that, having felt that he voted in a way that he no longer wishes to be on the record as having voted, in essence. And so that is what has happened in this situation. We are now, as a House, deciding whether or not we want to take that bill up again. So if you are voting yes, that means you would like a new vote on the bill. If you are voting no, you are satisfied with the vote that the House took and wish that to stand as the record of the House. There has been no request for a roll call. However, I knew that would happen. And that is sufficiently seconded. So this will be a roll call vote. Okay. I would remind members to please turn on your voting stations. The House will come to order Chair recognizes Representative Sylvia for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I understand that this vote is not on the underlying substance of the bill, and that a member being early in the term and junior members abound in the building may have been confused, may need to think about things again. And if I know that the underlying bill is a good pro-liberty, pro-business bill, and we really need to think hard about this, would I then press the green button so that we might reconsider this vote? Thank you, Mr. Speaker.
The question is on reconsideration on House Bill 269. This is a roll call vote. If you are in favor, you'll press the green button. If you're opposed, you'll push the red button. Chair recognizes Representative Rowe for parliamentary inquiry.
Thank you, Mr. Speaker. If you know, as I know, that the Judiciary Committee voted 13-2 for this, and if you know, as I know, we have a very fair and balanced Judiciary Committee, would you not join me and press the red button?
The question is on the motion to reconsider House Bill 269. If you are in favor, you'll press the green button. If you're opposed, you'll press the red button. Voting stations are open for 30 seconds. Have all members who were present when the question was put voted? House will attend to the state of the vote. There having been 145 members voting in the affirmative and 204 in the negative, the motion fails. The House will now attend to bills removed from the consent calendar. All right. The Committee on Criminal Justice and Public Safety, to which was referred House Bill 492, an act relative to military and historic reenactments and commemorations, having considered the same, report the same with the following amendment and with the recommendation that the bill ought to pass with amendment. Representative David A. Welsh for the committee. Representative John Thal is recognized for a motion.
Thank you, Mr. Speaker. Having been approached by several members during the session today, feeling that there's some less than clear portions of the bill, I move recommit.
Representative Thal moves that House Bill 492 be recommitted. Are you ready for the question? Are you ready for the question? All those in favor of the motion to recommit, say aye. Aye. Those opposed, nay. Nay. The ayes have it, and the bill is recommitted. The Committee on Election Law, to which it was referred, House Bill 133, an act relative to recounts on questions, having considered the same, report the same with the following amendment and with the recommendation that the bill ought to pass with amendment. Representative James P. Gray for the committee. The question is on Amendment 0123H, printed in House Record 11, page 197. Chair recognizes the member from Windham, Representative Bates, to speak against the amendment.
Thank you, Mr. Speaker. And I do rise technically in opposition to the amendment, but I do want to point out that I'm in favor of what this legislation is at least attempting to do. And it is my intention when I'm through with my comments, if the Speaker will recognize me again at the appropriate time, I'd like to make a motion to also recommit this bill back to the Election Law Committee because I believe the language needs to be perfected a bit. It's actually a fairly simple bill. The purpose of it is to provide notification to people who request a recount when there's a warrant article at town meeting, and as is the case sometimes, people are not happy with the outcome and they want to challenge that, ask for a recount. Now, in the case of an election, it's obviously crystal clear who the interested parties are. It would be the various candidates for a particular office. But in the case of a question on the town warrant, it's not so obvious who the interested parties are. So at the present situation is there's no requirement to give notice to anybody about or let me correct that. Notice of a recount has to be posted, but there's no requirement to give notice to any particular person. This legislation is intended to be sure that at very least the person requesting the recount is notified, and that's very appropriate. I support that. The problem is what the sentence says after that. And it's just one sentence that I'll read for you. It says, the clerk shall give reasonable notice of the recount to the first named voter who applied for a recount on a question. That's good. That's an appropriate change, and I'm supportive of that. The problem comes with what follows. The additional requirement is the clerk needs to notify that first named voter and a representative of other known interested parties. And as I read that, that is very unclear to me who the clerk is supposed to send the notice to. And so if you're a town clerk, and if that's clear to you, fine, you can ignore me and we'll move on with this. But if that is as unclear to you as it is to me, or if you are a town moderator or a selectman and can see the potential problems that language that is that vague may invite, I just anticipate seeing people after a recount is scheduled and they don't receive a notice because it's not clear who those interested parties are, much less who their representative is. I just think it's just too vague for the clerk to clearly know who they should send that notice to. And I'm concerned this could lead to lawsuits because a person wasn't notified of a recount, or at very least, selectmen and town councilors have to field questions from angry people who weren't notified. As far as who should be getting this notice, again, it's crystal clear. The person requesting the recount, that's good. If we were to speculate who these other individuals might be, it's certainly arguable that anybody who stood up at town meeting to argue for or against a particular question, it's reasonable to presume that they're an interested party. Or if this warrant article was the result of a citizen petition, there could be 25, there could be 50 people who signed that petition. Arguably, all of them are interested parties. And my question is, would the clerk have to send notice to all of those people? Suppose that this warrant article happens to be on a zoning issue. Is everybody in the affected geographic area that is affected by that zoning change, or the abutters as well? Are all of those interested parties who should be notified? I don't know. I would just say to you that I think that the language as written in this amendment is not clear enough, and so I would be seeking to make a motion to simply recommit this, because I think it's proper that notice is at very least sent out to the people who requested the recount. But as far as who the other interested parties are, if the Election Law Committee feels that there are other people who should be notified, I wouldn't take exception to that, but I do think the law needs to be much clearer in who the clerk is obligated to notify. Thank you, Mr. Speaker.
Thank you. Your motion is not recognized at the present time. The member from Rochester, Representative Gray, is recognized to speak for the committee.
Thank you, Mr. Speaker. Thank you, Representative, for the question. I believe that the representative has not only made the argument for that the words are unclear, but he's also told you why they are unclear. There is very, very, very many different reasons why we may not know exactly right now who we should notify. This legislation only applies to town meetings. Town meetings, we do have the people getting up. We do have the people that are testifying. We do have people who are doing petitions. And making it a little vague, my opinion, gives you that latitude. We did not have a requirement for notification until now. Why do we have it now? Because there was someone who felt that they should have gotten notified that didn't. The Town Clerks Association took that information and through discussion with various legislators have put this bill together. It is a good bill. In addition to the words that are in there, we also have a posting requirement that it shall be posted for, I believe it's 2 days, 3 days before. That same requirement that is in RSA 660, RSA 669 for other elections, as it is here for the town meetings. That sending it back to the committee, I don't know what words to put in. Maybe I would put a laundry list in that would give everyone that I could think of, but you know what? At the bottom of that list, it's going to be other interested parties. So that is why the committee believes that the bill should pass as amended.
Will the member yield to a question? Will the member yield to a question?
For the sake of time, no.
All right. No. Question is on the amendment. At this time, the chair recognizes the member from Windham for a motion of higher priority.
Thank you, Mr. Speaker, and I would move to recommit this to the Election Law Committee, and I'd like to speak to that.
You are recognized to speak.
Thank you. I've pretty much already laid out my concerns with the amendment as it is written. And if it's clear to you, if this were to pass into law who the clerk is supposed to notify, then you are welcome to defeat this motion. But if you look at this and you read the words that the clerk is to notify a representative of other known interested parties, if that needs clarity to you, I would encourage you to vote yes to the motion. I'm not trying to kill the bill. I'm not trying to kill the amendment. Just send it back to the Election Law Committee so they can clarify that. We certainly appreciate the work, all the work that's been done on it and the input from the town clerks and all that have had input to it. But I believe that the clarity that is needed is not there, and I would encourage you to vote yes to this motion.
Will the member yield to a question?
Sure.
Representative Itzy, you may inquire.
Thank you, Mr. Speaker. Thank you to the member from Salem for taking my question. I'm sorry, Windham. Could you not as easily construe that list of interested parties from some particular list of individuals to every registered voter in the town?
Again, my concern here is that it is unclear who the interested parties are, who the other interested parties are. In fact, it says the known interested parties. It doesn't say known to who. Is it known to the clerk? Is it known to the moderator who conducted the meeting? Is it known to the selectmen? It's just unclear. And so some might reasonably conclude that it is all of those people. I don't know. I just encourage us to move this back to election law to get better clarity. Thank you.
Chair recognizes the member from Raymond, Representative Hosel, to speak against the motion to recommit.
Thank you, Mr. Speaker. I believe that the committee did due diligence on this. We had the town and city clerks. we had the Secretary of State. They were all involved in the amendment. I think that you could make this so long with the lists that you will put out that you're still going to miss someone. And so I'm firmly against recommitting this. The committee did do due diligence. Thank you.
The question is on the motion to recommit. Are you ready for the question? Does the member yield to a question? No. Division has been requested. This will be a division vote. Members, please take your seats. Waiting for the doors. So. House come to order. The question is on the motion to recommit. All those in favor say aye. Excuse me, what the? If this is a division vote. All those, you don't need to do that. I'm used to parliamentary inquiries. Nobody's doing an inquiry, so I'm just going to say, find my sheet and say, this is a division vote. If you are in favor of recommitting the bill, you will press the green button. If you are opposed, you will push the red button. Voting stations will be open for 30 seconds. All members voted who were here when the question was put. The House will attend to the state of the vote. There having been 157 members in the affirmative, 193 in opposition, the motion fails. The question is on the adoption of the amendment. Are you ready for the question? All those in favor of the adoption of the amendment, say aye. Aye. Those opposed, nay. The ayes have it, and the amendment is adopted. Question is on the adoption of the committee report on House Bill 133 as amended. Are you ready for the question? All those in favor signify by saying aye. Aye. Those opposed, nay. No. The ayes have it, and the committee report is adopted. The Committee on Health, Human Services, and Elderly Affairs, to which it was referred, House Bill 101, an act relative to prescription refills, having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative Lucy M. Weber for the committee. Chair recognizes Representative Dan McGuire of Epsom to speak against the committee report.
Thank you very much, Mr. Speaker, members of the House. I can't recall another case where the wheels have come off a bill in the committee process like this one. This bill, in a much more general form, passed the House on consent 2 years ago, so we all voted for it. So somehow today, in a more targeted, narrow form, we're all going to vote against it? I mean, that just makes no sense at all. So I'm going to tell you what the bill is about. This is a really simple bill that would allow patients to get prescriptions for 90-day supply of their medication rather than requiring them to get only 30 days supply. This is a maintenance medication, something they're going to take for long, long periods of time. And the law currently requires them to get only 30 days supply, so that means they have to refill their prescriptions 12 times a year instead of 4 times a year, thus encountering 8 extra copays. The drug in question is topical testosterone. Topical androgen is what it's called. What it is an alcohol gel, just like hand sanitizer, with some testosterone mixed in. It's rubbed on the skin, and it's used by men, typically elderly men, who have low testosterone, and to boost their testosterone back to normal levels. According to statistics, 1 in 200 men suffer from this condition, and so that means we're talking about 2,500 men in New Hampshire. If only 40% of those are getting treated for that condition, we're talking about 1,000 people getting these prescriptions. And typically from Anthem, this kind of prescription requires a $40 copay. So 8 extra copays a year times $40 is $320 a year per senior. And if you times that times 1,000 men, we're talking about maybe $250,000 a year that we could lower health costs with no effort at all, just pass this bill, very, very simply. So that's the benefit. We're trying to help out, again, typically seniors who want to save a little bit of money on their copays. Is there any harm in this bill? And this is where I think the blurb that you might read in the calendar just simply doesn't make sense. The reason we have this restriction in law that certain kinds of prescriptions can only be put on a 30-day supply is for the kinds of drugs that can be abused by the patient. So if you're getting, I don't know, codeine or cocaine or some kind of drug that can be abused by the patient, and you take yourself a 90-day supply in a short period of time and get hooked on it, that's what we're trying to prevent with this particular law. We're trying to say you can't get too big of a supply, we don't want you to hurt yourself with that drug. But this particular drug, this topical testosterone, is not the sort of thing that can be abused. I spoke to my endocrinologist about this. He says in order to abuse this drug, it's so mild, you'd have to fill a bathtub with it and soak in it, you know. And we're talking about a drug that costs like $250 for a tiny bottle. You know, it's not something that anybody can misuse as a patient. The blurb mentions possible danger to women and children. Whatever the danger is to women and children, and it's very, very minor, I'll talk about that in a minute, that danger comes from the single open bottle that the person is using, not extra bottles that might be in a drawer or on a shelf or whatever that are closed in a box. We're talking about if some woman or children accidentally uses this drug, they're going to use the open bottle that's sitting on the counter, right? I mean, that's where any possible danger comes from. But really, I have, by the way, with me, the insert that comes with this drug, and it's you know, it's tiny print. There is absolutely nothing, this is printed on both sides, there is nothing in here about swallowing the drug at all, right? And the reason this is something that you rub on your skin is because swallowing it wouldn't do anything for you, right? The stomach digests testosterone. So, you know, you can't have a pill that does it, and this particular drug is simply not toxic. What they talk about in here in terms of danger to women, they did a little experiment, and what they did with that experiment was they had men put on the drug, rub it onto their shoulders, and later they had women touch them with their hands, their wrists, their arms for 15 minutes. And later they measured the testosterone level in the women, and it was up 300% from their normal testosterone level. All right? And the danger is, if you do that a lot, then women might start to get deeper voices and facial hair and stuff like that, right? But you have to do it a lot. I mean, it's not something that is any real danger. So, no danger from swallowing, no danger to women and children. What else? Oh, the other thing that the blurb mentions is we don't want to micromanage this, right? I mean, we just go by category. There's extremely large categories of drugs that you can only get 30-day supply of, and we don't want to say, okay, this one is an exception and that one's an exception, too much trouble, right? Well, this particular law, in the same paragraph that this bill affects, there's already an exception for Ritalin. Ritalin is an amphetamine. It's an amphetamine used by children, and it's something that has street value. It's something that college kids can abuse when they want to stay up all night and that sort of thing. So there's an exception. Normally, Ritalin would be in this category and would be required to have a 30-day supply. But we somehow in the past have made an exception for it. So that, to me, is a slightly dangerous drug, but we said, hey, we want to save people a little money on their copays. Why not do it for this, for seniors, for something that is really very mild and is not an issue? So again, here's a very simple way we can save some seniors some money. Let's do it. Thanks.
Question. Sure. Representative Itzy, you may inquire.
Thank you, Mr. Speaker. Thank you, the representative, for taking my question. Just to clarify, this is a drug with no ill side effects, no danger really of overdose or misuse. Can you tell me why we are grouping it with drugs like hydrocodone so that we are not allowing a 90-day low copay prescription?
Okay, thank you for the question. So basically, testosterone itself, in a more concentrated form, is in the category of steroids. So basically, what makes Barry Bonds hits the home runs, or Jose Canseco, or Arnold Schwarzenegger look like Arnold Schwarzenegger, can be testosterone. I mean, that's what it is. And so, but it's the injectable form of testosterone is required for that. If you want to be a bodybuilder or an athlete and abuse testosterone, you need the injectable form, which is much, much more concentrated. You need to get your testosterone up many, many times the normal level. This is just a little supplement that gets you, for people that are a little bit below, can get them back to the normal level. So this is not something that can be abused. Thank you.
Chair recognizes the member from Hooksett, Representative Katowski, to speak in favor of the committee report. Oh, excuse me. I apologize. I'm recognizing the member from Rochester, Representative Bowden, to speak against the committee report.
Thank you, Mr. Speaker. I want to talk a little bit more about Ritalin. The honorable representative from Epsom hit on that. And, you know, I wonder, as I read the legislation that's currently in effect, why do we allow more than a 34-day supply of Ritalin? I don't know the answer to that question. I doubt anybody in here does. Maybe some people do. But the point is, that discretion is left to the doctor and the pharmacist. If they feel there is a need for more than a 34-day supply of Ritalin, they're free to grant it, according to our statutes. But our statutes prohibit them from granting more than a 34-day supply of Axiron or one of the other topical steroids to treat low testosterone. I urge you to overturn the committee recommendation and so that another motion can be made. Thank you.
Chair now recognizes the member from Hooksett, Representative Katowski.
Thank you, Mr. Speaker. And to my good friend from Epsom, I want to say I was really impressed with the knowledge that you have about the material you're talking about. However, I won't be overly endowed with evangelistic zeal today. I will instead appeal to you that the vote in committee, my committee, was 14-0. We listened to testimony on all sides of this issue. It became very clear to me, and quite honestly, I signed on to that bill early on. But in listening to that testimony, it became obvious that carving out one or another drug from a particular class of drugs is not the right thing to do. The Food and Drug Administration, for good reason, classifies drugs, puts them in a particular category to do a couple of things. It's really about safety and security. Now, we can argue all day about the effects of a particular medication and how one is benign and another is not. But the fact remains that as a policy committee, our committee must make sure that when we make a recommendation, it has to do with safety and security of that material. So, I would urge all of you to not think too much about what it costs or how long the prescription is, but rather to make sure that we as a legislature do not allow drugs of these kinds of classes, whatever it is. And yes, Ritalin does have an extended period if a doctor wants that to happen. This should not be about cost, nor should it be about convenience. I urge you not to support the view to overturn that legislation. The committee worked hard and long. Thank you.
This will be a division vote. This will be a roll call vote if it's sufficiently seconded. And it is sufficiently seconded. Who requested the roll call, please? Representative Rideout requests the roll call. Members will please take their seats. Yes.
Don't be that way.
The House will come to order. The chair recognizes Representative Greg Hill for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that this bill will save patients $300 a year in excess copays for an estimated total of $300,000 a year in New Hampshire residents, if I know that it will also save pharmacists and insurance companies by cutting the number of prescriptions they have to process, and if I know there is no harm in having a few extra sealed bottles on the shelf, and if I know that doctors can and should make decisions about prescription dosages and refill frequency and not legislators, would I now press the red button and so an alternate motion can be made? Thank you.
The question is on the adoption of the committee report on House Bill 101. This is a roll call vote. If you're in favor, you'll press the green button. If you're opposed, you'll press the red button. The chair recognizes Representative Katowski for a parliamentary inquiry.
Mr. Speaker, if I know that protecting all classes of drugs from getting out into the public trumps cost, convenience, or whatever, would you join me in pushing the red button? The green button.
The question is on the adoption of the committee report on House Bill 101. This is a roll call vote. If you are in favor, you'll press the green button. If you're opposed, you'll press the red button. Voting stations are open for 30 seconds. If all members voted who were here when the question was put, House will attend to the state of the vote. There having been 191 in favor and 151 opposed, the committee report on House Bill 101 is adopted. The Committee on Judiciary, to which it was referred, CACR 8, an act relating to the nomination and appointment of officers, providing that the judicial officers shall be confirmed by the legislature. Having considered the same, report the same with the following resolution: resolved that it is inexpedient to legislate. Representative David Woodbury for the committee. Chair recognizes the member from Dunbarton, Representative Hall, to speak against the committee report.
Thank you, Mr. Speaker. CACR 8 is before you because of some of the issues we've seen with the judicial system. Over the years, there's been a number of potentially either bad rulings, maybe bad cases in divorce, for those who saw the film on divorces yesterday. And currently, the only nomination process available to us is that of the governor with concurrence of the executive council. Historically, the executive council, it's my understanding, the executive council was made up of actually members of both the House and the Senate. The representative from Fremont could probably better speak to that than I could. But in the meantime, there is a way to change it, and it's to adjust what's in Article 46, Part 2 of our Constitution, which talks about what the nomination process could be. People have asked that we elect judges instead. That is a possible process. We could write a constitutional amendment that would allow for the election of judges. Instead, seeing as this body is the body that best represents the people, the easiest way to amend this would be to allow the elected members of the House or the Senate or both or a committee of those to make the decision for the people on is this the appropriate member for the judicial branch. I would ask that you would support the overturning of the ITL so that we can, in fact, make a motion of ought to pass, so that we could, in fact, start the reformation of the judicial system. Thank you.
Chair recognizes the member from New Boston, Representative Woodbury, to speak in favor of the committee report.
Thank you, Mr. Speaker, colleagues. I do urge you to support the ITL of the Judiciary Committee. Before going any further, I want to be very clear that I think it's a universal feeling among the people of New Hampshire that our judges are second to none, and they're wholly competent, wholly ethical, and wholly good choices. And this is a decision that's been made by the governor and council for many, many years. The question to be debated here is to whether or not the legislative branch ought to be involved in a selection of judicial officers. Now, that's a very common thing in this country, particularly in states that do not have an executive council. The federal government, of course, has all of these officers selected or confirmed by the Senate, and that's true in a good many states as well. But this bill presents some unique problems. First of all, it calls for a nomination to be made either by the governor or by the executive council. Now think about that for a minute. You have dueling nominations. You certainly have the possibility of that. Then, once that may be resolved, you form a committee or the joint session of the House and Senate to confirm the nomination. Now that involves, as you know perfectly well, convening 424 people to pass on what may be a very non-controversial nomination to a judicial slot in the circuit court or superior court. Think about the practicality of doing that. Then imagine that this opening occurs while we're all at home doing things that we do at home. September, October, November. Are we then going to bring in 424 people to pass on a judicial nomination that needs to be filled and shouldn't have to wait until we're all here doing other business, so that while I'm not opposed to the concept of bringing the legislative branch into the judicial selection process, that's a very common thing over the country, this bill just raises particular practical considerations that would simply make it unworkable, and for that reason it ought to be rejected. If the objective is to somehow to reduce or somehow change the political input into the selection of judges, I can't imagine a more political arena than the 424 of us in joint session compared to the present system. This just brings to mind the maxim of, if it ain't broke, and we know it isn't broke, don't fool with it. So I urge you to uphold the Judiciary Committee and confirm the ITL. Thank you.
Representative Hull has requested a roll call vote. Is that sufficiently seconded? It is sufficiently seconded. Members will please take their seats. House will come to order. The chair recognizes Representative Hall for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that Article 46 doesn't speak to the nomination of civil officers, but it should, if I further know that the Article 46, Part 2 of our Constitution only allows 3 days to vet nominations to various offices, including those of the judiciary. If I further know that Article 46 only allows a group of 5 people, 6 including the governor, to make the selections of who would be on part of the judicial branch, and some of those appointments could be for up until age 70. If I further know that 2 choices potentially for nominations before this body would be better than 1. If I further know that for those who saw the divorce court movie yesterday, there are issues in the judicial system, would I now vote red so an alternate motion could be made?
Question is on the adoption of the committee report on CACR 8. This is a roll call vote. If you are in favor, you will press the green button. If you are opposed, you'll press the red button. The chair recognizes Representative Rowe for parliamentary inquiry.
Thank you, Mr. Speaker. If you know, as I know, having a joint session of the House and Senate called in July and August and September for the appointment of civil officers, judges, attorney general, and others, would in fact increase the partisanship of these appointments, would delay these appointments, and would increase the cost of these appointments. And as Representative Woodbury said, if it's not broke, don't fix it. Press the green button.
The question is on the adoption of the committee report on CACR 8. This is a roll call vote. If you are in favor, you'll press the green button. If you're opposed, you'll press the red button. Voting stations will be open for 30 seconds. Have all members voted who were here when the question was put? House will attend to the state of the vote. There having been 242 in favor and 101 opposed, the committee report is adopted. The Committee on Judiciary, to which it was referred, House Bill 246, an act relative to jury nullification, having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Paul S. Birch for the committee. The chair recognizes the member from Dunbarton, Representative Hall, to speak against the committee report.
Thank you, Mr. Speaker. HB 246 is simple. All it does is add effectively a penalty that we could enforce on judges who haven't, in fact, allowed the defense to issue what is known as the Wentworth decision or jury nullification. This may involve a few minutes of instruction and background. In 2012, we passed what is known as jury nullification. The bill started in the House, was changed along the way, and then passed into law. One of the citizens of New Hampshire chose to use that in his defense, a case that ultimately ended up in the Supreme Court and was decided this past October, or the decision was handed out, I guess, this past October, in which the Supreme Court went ahead and said Since you didn't say blah, 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 but you said blah, blah, blah instead, this isn't jury nullification. We're not going to allow you to use this. And unfortunately, that defendant was found then guilty. The question before you today is, do we want to allow our citizens who are members of the jury to have the authority to judge not only whether the person is innocent or guilty of the crime, but to judge whether the law itself makes sense and makes common sense, I guess. Jury nullification was kind of one of the bedrock institutions of how our country came to be in the judicial system. It allows us to have an independent group of people kind of oversee the legislature in case we err. That never happens, but in case we did, this would allow citizens to weigh in and say, you know, that really doesn't make sense. The misdemeanor to cut a child's hair, for instance, is a bit much. Maybe a fine would be acceptable. So if someone was charged and convicted of cutting their neighbor's children's hair and they were handed a misdemeanor, would we want the jury to weigh in and say, you know, that's a bit of an overreach? So here we have a bill before you that will penalize the judge if he fails to let someone have the Wentworth instruction. That's all it does. There will be multiple jury nullifications bills this year. This is the first of many. My recommendation would be that we would overturn the committee report, send it back so that we can actually have a subcommittee on this and the others to merge them into one bill that is worthwhile for the House to support. I ask that you vote against the committee recommendation of ITL. Thank you.
Chair recognizes the member from Belmont, Representative Sylvia, to speak against the committee report.
Thank you, Mr. Speaker. We'll hear a little bit, or probably a lot, with the rest of the jury nullification bills coming through. And there's reference to the Wentworth instruction, which the court gives to the jurors. The court feels that the Wentworth instruction is satisfactory to inform the jury of their right to nullify our laws. So the Wentworth instruction is 2 sentences, so if you'll bear with me, I'll read them to you. To the jury, if you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the offense charged beyond reasonable doubt, you should find the defendant guilty. Did you get where that gives you, the juror, the right to nullify the law? Now, we here are particularly tuned into the 2 words that give that nullification instruction. Make sure I get them right. Where are they? They're hiding on me, I'm sorry. So there is the command, must, thank you, and the more permissive, should. The difference there is to be picked up by the jurors while they're getting their instructions from the judge. That's insufficient, in my opinion, and I don't think that notifies the jury properly of their right to judge the law. So I'd ask you to please overturn the committee report and vote red. Thank you.
The chair recognizes the member from Westmoreland, Representative Birch, to speak in favor of the committee report.
Thank you, Mr. Speaker. I think a little clarification at the beginning might be useful. I'll try not to be too long. To explain why New Hampshire does not have jury nullification law, nor to my knowledge does any state. or under the federal system. The easiest way perhaps to understand jury nullification is to think of three parts. When a jury considers, there are the facts, there's the law, and there's the application of the facts to the law and the law to the facts. Those are the three parts. In New Hampshire, including the statute that was passed in 2012, talks about two of those parts, not three of those parts. And the statute that was passed in 2012 is pretty easy to follow. In all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts, that's one of them, and the application of the law in relation to the facts, that's two, in controversy. You didn't hear anything about a jury having a right to decide the law. So, we do not have jury nullification. We did not pass jury nullification. This went up to the New Hampshire Supreme Court, the interpretation of this law last year, as one of the representatives, or perhaps both, suggested, and it is true. And the New Hampshire Supreme Court said, the language should sound similar, in conclusion, the law requires the trial court to allow the defendant to inform the jury of its right to judge the facts and the application of the law in relation to the facts in controversy. It does not require the court to allow the defendant to inform the jury that it has the right to judge the law or right to ignore the law. In other words, it is not a jury nullification statute. Goes on to say in other parts of the decision, if it were, there might be significant constitutional issues with it. Okay, there will be a bill coming up that is specific as to jury nullification. This bill simply says if the judge limits his or her instruction to the Wentworth instruction, which has been approved by the Supreme Court, that judge is subject to impeachment. The Judiciary Committee, I think 13-2, might have been 14-2, felt that A, the bill was written in a somewhat incomprehensible manner, and B, should not subject a judge to impeachment. If a judge did something technically wrong in a trial, it is subject to appeal, not impeachment. And third, the way the bill is written, a judge could be punished by impeachment for doing exactly what the New Hampshire Supreme Court and the legislature said the judge should do. So the recommendation of the Judiciary Committee overwhelmingly and bipartisan was to ask that this bill be ITL'd. Thank you.
The question is on the adoption of the committee report of ITL on House Bill 246. Does the member yield to a question? Member does yield. Representative Pohl, you may inquire.
Thank you for taking my question. In the case that I mentioned before, did the Supreme Court rule the following? HB 146 contained language that would have given the jury the right to judge both the facts and the law. It stated, in all court proceedings, the court shall instruct the jury of its inherent right to judge the law as well as the facts, and to nullify any and all actions that they find unjust. The court is mandated to permit the defendant or counsel for the defendant to explain this right of jury nullification to the jury, but that they found that that was changed along the way, and because it failed to say those exact words, it's not jury nullification?
I'm not sure where you're reading from, what case you're reading, what quote is
I'm
from.
reading from the Rich Paul case from Supreme Court. It is on page 5, middle of page 5.
What I'm reading at page 5 is that the court went through the history of the bill. Is that the
Yes,
section
it went through
you're
the
reading?
history and explained.
And then went on as, went through the amendments to the bill and said, as ultimately enacted, contain only the requirement that the court permit the defendant to inform the jury of this right to judge, which sentence before, to judge the facts and the application of the law to the facts and controversy. It says that's all the bill contains.
Follow up.
Will the member yield to a follow-up question?
No, I think we've done enough.
Member does not yield. This will be a division vote. Members, please take your seats. Representative Burke requests a roll call. Is that sufficiently seconded? It is sufficiently seconded. Members will take their seats. Have all members voted who were present when the question was put? Oh, jeez. I am getting tired. There was way too much plowing in the last couple of weeks. I'm lucky I'm still on my feet at times, so I'm just wishing we were there. I apologize. House will come to order. The chair recognizes Representative Itzy for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I believe that, well, if I know that I was here in 2012 and I believe that I was part of passing a jury nullification law, if I know that that law says that the jury can be informed that they have the power to judge the application of the law to the facts, and therefore to find the law, though generally applicable, not applicable to the facts in controversy, to nullify it in particular, would I now decide to stand up for the decision that this general court made and push the red button?
The question is on the adoption of the committee report on House Bill 246. This is a roll call vote. If you are in favor, you'll press the green button. If you're opposed, you will press the red button. The chair recognizes Representative Rowe for parliamentary inquiry.
Thank you, Mr. Speaker. If you know, as I know, that if a judge makes an unintended mistake on the instructions to a jury, it doesn't have to be deliberate. It can just be a mistake. With this bill, that judge would be guilty of, it will be an act of maladministration, which is one of the 4 conditions, any one of which you can impeach a judge. This is extremely, if you know as I know, Mr. Speaker, this is an extreme consequence. Would you not press the green button and support the 14-1 decision of the Judiciary Committee?
Question is on the committee report on House Bill 246. This is a roll call vote. If you're in favor, you will press the green button. If you are opposed, you will press the red button. Voting stations are open for 30 seconds. All right, now have all members voted who were here when the question was put? I heard a no. It's not a time to be playing games. Member, the House will attend to the state of the vote. There having been 225 in favor and 115 in opposition, committee report is adopted. The Committee on Legislative Administration, to which it was referred, House Bill 338, an act relative to nomination of candidates for United States Senator, having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Jack B. Flanagan for the committee. The chair recognizes Representative Dan McGuire of Epsom to speak in opposition to the committee report.
Thank you very much, Mr. Speaker, members of the House. If I were to ask you, what do you think is the biggest, whatever that means, what is the biggest problem facing us as Americans today? I think, at least in the conversation, might be the size of our runaway federal government. By one measure, we have the federal government has an unfunded liability of $127 trillion. And to put that into perspective, the size related to New Hampshire is roughly 0.5% of the country in population, would be $600 billion. So our own state unfunded liability at $4 billion is a drop in the bucket compared to our part of the federal government's unfunded liability. And that's to just give you a hint at the size of the problem. It wasn't supposed to be like that. When the federal government was created, and it was created just down the street there on Main Street where it was finally ratified. When the federal government was created, Madison wrote in Federalist 45 that the federal government would just be small. It would be about foreign affairs, it would be about defense, and all the rest of society and issues would be left up to the states. Well, and part of his reasoning for why that would happen was the fact that senators, U.S. senators, were chosen by state legislators. And so senators would never let the federal government run over their state legislatures because they were beholden to them. Well, that worked for close to 150 years. But then came along an era when we saw such great ideas as the income tax, the 16th Amendment, Prohibition, the 18th Amendment, and the one we're talking about here, which is the 17th Amendment, which was the popular election of senators. The way our government was designed, our federal government, it was designed to have balance between lots and lots of competing interests. The House was about the people, the Senate was about the states, there was the balance between the three branches of government, and so on. But the fact that when we switched to popular election of senators, all of a sudden our state government had nobody in Washington who represented them, right? There was nobody in Washington who was directly elected or a representative of our state governments. And over time, Washington got bigger and bigger and bigger, and we became an appendage. I can't tell you, when we work on the state budget, how much we do that is directed and controlled and related to how much federal money we get sent, right? If we cut this, we're not getting this federal money, or the feds require this, and so on. Just to give you an example, our own Department of Education, 3/4 of their employees are being paid their salaries from federal grants. 1/4 of them get their salaries from us. I mean, that's just a tip of the iceberg. So what does this bill do? This bill is a clever design to partly undo the damage of the 17th Amendment. It would change the way names get on the ballot for U.S. Senator. It would have the New Hampshire House, each party in the New Hampshire House caucus and choose a candidate for the primary ballot for U.S. Senator, and each party in the New Hampshire Senate caucus and choose their candidate for the ballot for U.S. Senator. It would still allow write-ins, so anyone could become a senator, but as far as the primary ballot goes, there would be the New Hampshire House candidate and the New Hampshire Senate candidate from each party. And then the general election would be ordinary. This means that rather than just signing up on the basis of cash or signatures, someone would have to get the imprimatur of the New Hampshire legislature in order to be a U.S. Senator. So it's a way to get a little bit more control over our federal government without having to go through the trouble of trying to undo the 17th Amendment. It partially gets us there part of the way. So one of the arguments when we talked about this in the Legislative Administration Committee was that this might be against our own Constitution. There's a provision, the last sentence of Part 1, Article 11 of our Constitution reads, "Every inhabitant of the state having the proper qualifications has equal right to be elected to office, to be elected into office." So at the time, I hadn't researched this section, and I have since. And basically, what this comes from, this provision in our Constitution was copied from the Massachusetts Constitution in 1784. And at the time, it was very simple. It just read that anyone who's qualified to vote is also qualified to hold office. So it was making a connection between if you can vote, you can hold office, and vice versa. And so, but it was intended to deal with things like felons not being allowed to vote, but therefore they're also not allowed to hold office. Women, not allowed to vote, not allowed to hold office, you see? So over the years, that particular paragraph in our Constitution has been expanded, and we've added things like disabled access to the ballot, to the voting place, and things like that. So it's a much, much larger thing. And this particular sentence got split off from voting. It's now just about holding office, and it's been pushed lower and lower in the paragraph, but it's just never changed. This sentence has been litigated 3 times. Once, by the way, the opinion in our Supreme Court, once the opinion was written by our distinguished House counsel, Mr. Douglas, and of the 3 times, 2 had to do with felons who wanted to be elected to office. In one case, there was a selectman who committed his felony after he was already in office, and he argued because he served less than a year in jail, he should still be a selectman. In all cases, it was this litigation had to do with whether somebody was in office or not at all. It didn't have to do with ballot access or anything of the sort. The most litigation had to do with, in 1927, when women were given the vote. So in the U.S. Constitution was changed so that women were given the vote, and therefore everybody understood that if women can vote, they can also hold office. But the question that came before the New Hampshire Supreme Court was, well, what about appointed offices? Clearly, voting and elective office are connected, but what about appointed offices? Could women be appointed to office without any other action of the legislature? And you might be surprised, but the New Hampshire Supreme Court ruled that of course not. That by common law, women couldn't hold appointive office, and that this particular sentence was only about elective office, and therefore women weren't qualified unless the New Hampshire legislature made a change. So in general, the question of whether this particular bill has been considered by the New Hampshire Supreme Court or not, the answer is no. Nothing like it has ever been considered. Will it lead to litigation? Yes. Will we win? I don't know. But the problem that we're trying to deal with, the runaway federal government, is so overwhelming, we ought to do whatever we can to fight back. Thank you very much.
Chair recognizes the member from Brookline, Representative Flanagan, to speak in favor of the committee report.
Thank you, Mr. Speaker, and thank you, colleagues. So we heard it. This bill is about us electing U.S. senators. Actually, the Senate, too, that they'd be part of it. And in New Hampshire, we pride ourselves on the direct and personal access citizens have for candidates of office. Politics and elections are one of our many passions. You okay, Representative? Thank you. We take elections very seriously. I mean, just look at the presidential primary. I mean, we're standouts on the national scene as far as what we do and how we handle vetting the candidates. Could you imagine if we voted for this and we went back to our constituents and said, by the way, we took away your opportunity to vote for your senator. Sorry, we're going to do it. I just cringe at that thought. The voters of our state deserve the opportunity to participate directly with the nomination and election of our senators or any other elected official, plain and simple. And I ask you to support the unanimous vote of the Legislative Administrative Committee and support the ITL of this bill. Thank you very much.
The question is on the committee report on House Bill 338 of inexpedient to legislate. This will be a division vote. Representative Lehman requests a roll call vote. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. Members, please take your seats. House will come to order. Question is on the committee report on House Bill 338. Chair recognizes Representative Hall for a parliamentary inquiry.
Thank you, Mr. Speaker. If I know that when our constitutions, both in this case the federal, was written, that direct election of senators was not their intent. Their intent was actually to have the states put the senators in office, primarily to make sure the states were being well represented themselves. If I further know that we've seen in the year 1913, the Federal Reserve instituted, an income tax instituted, that we may not have made the right decisions that year. If I further know that...
Will the member please suspend? Chair, member was recognized for parliamentary inquiry, not to make statements on legislation that has passed.
Thank you. I'm asking a question about why the 17th Amendment needs to be annulled or repealed, but we can't repeal it as a state house, so we have to, there's another option. If I further know that it would be difficult to actually repeal the 17th Amendment, but that the states have an interesting option themselves, and that option would be to
Member
allow...
will please suspend. You were recognized for a parliamentary question, not to make statements. Member continues to make statements.
Mr. Speaker, if you believe, as I believe, that allowing the states to choose who gets nominated and is put on the ballot in the primary, and if you believe, as I believe, that the voters could then choose in the general election who should represent them as U.S. senators, would you now press the red button so an alternate motion, or would I now press the red button so an alternate motion could be made?
The question is on the committee report on House Bill 338. This is a roll call vote. If you are in favor, you will press the green button. If you're opposed, you will press the red button. The chair recognizes Representative Shurtleff for a parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know it's presumptuous and wrong for any member of this body to think the General Court is far superior in picking candidates for the U.S. Senate than the electorate of New Hampshire, and Mr. Speaker, if I know the voters of the Granite State have a long history and tradition of electing the best and the brightest in selecting their candidates for higher office, after all, they elected us, would I now push the green button? Thank you, Mr. Speaker.
The question is on the committee report on House Bill 338. This is a roll call vote. If you are in favor, you will press the green button. If you are opposed, you will press the red button. Voting stations will be open for 30 seconds. Have all members voted who were present when the question was put? The House will attend to the state of the vote. There having been 252 votes in the affirmative, 75 in the negative, the committee report is adopted. The Committee on Legislative Administration, to which it was referred, H.R. 6, an act recognizing February 26, 2015 as the 23rd anniversary of the Khojaly tragedy in Azerbaijan. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Lucy M. Weber for the committee. The chair recognizes Representative Hinch for a motion.
Thank you, Mr. Speaker. Mr. Speaker, I move to table H.R. 6.
The question is on tabling of H.R. 6. Are you ready for the question? All those... A division vote has been requested. Members will take their seats. The request for division has been withdrawn. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it, and the bill is tabled. The Committee on Legislative Administration to which it was referred, H.R. 8, an act commemorating the 50th anniversary of the Social Security Act of 1965, having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate. Representative Jack B. Flanagan for the committee. The chair recognizes the member from Durham, Representative Horrigan, to speak against the committee report.
Thank you very much, Mr. Speaker. Half a century ago, President Johnson signed the Social Security Act of 1965 into law on July 30th, 1965, logically enough. This act created the country's first national health insurance programs, Medicare and Medicaid. Medicare guarantees affordable health insurance to all Americans age 65, as well as to the severely disabled of all ages. Medicaid provides matching funds to all 50 states, including New Hampshire, for programs serving the poor and disabled. This was no ordinary piece of legislation. It's a great step forward for the American people, and its anniversary deserves to be celebrated, and that's why I introduced the House resolution. We introduced the House resolution. Are these programs perfect? No, but they have made a huge difference in the life of the average American. For example, my father died in 2011 when he's 80 years old, and at least in that respect, he was average. 50% of his male contemporaries outlived him, or will outlive him, along with 64% of the women. My mother is amongst that fortunate 64%. In the 1960s, only 25% of the men and 43% of the women lived that long. So before Medicare, only half as many men lived to be 80, and only 2/3 as many women. So I think this was something worth celebrating, so I urge the House to overturn the ITL report so an alternative motion can be introduced. Thanks.
Chair recognizes the member from Rindge, Representative Emerson, to speak against the committee report.
Thank you, Mr. Speaker. I normally don't get up and go against a unanimous committee report, but today I felt I had to because it's the right thing to do. Let me give you a little background history on Medicare. In 1912, President Theodore Roosevelt included social insurance for sickness and in his platform for his progressive party. In 1915, a group of legislators tried to introduce legislation to introduce a medical insurance bill, and all of that was defeated. As a result, controversy about a national insurance came about. Let's see. The people supporting this was the American Nurse Association, the American Hospital Association, the American Social Workers Association, school nurses, and the American Medical Association, and the Chamber of Commerce's. And with all that support, the legislation still failed. In 1935, President Franklin Delano Roosevelt signed the Social Security Act, but medical was left out. The committee that President Roosevelt appointed to study this was concerned that by amending the bill, they might lose the entire Social Security Act. So Harry Truman, when he became president, took on the idea of national medical health care and tried to instigate that in his Fair Deal program. Truman's attempts were also unsuccessful throughout and during his presidency. Congressman Wilbur Mills, chairman of the powerful Ways and Means Committee, later played a huge role in creating the American Health Care Program. In 1964, when Lyndon B. Johnson was elected president, and the Democrats controlled both the presidency, the Congress, and a 2-to-1 margin in the Senate, the House Ways and Means Committee had shifted a lot of the old Southern Democrats, making this committee more sympathetic towards health care reform. The National Academy of Social Insurance study panel examining implementation issues associated with reforming the American healthcare system said, and I quote, "No person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in or denied the benefits of Social Security or be subject to discrimination under any program," end quote. On July the 30th, 1965, President Johnson signed the bill, making it a public law. The signing took place in Independence, Missouri, and was attended by President and Mrs. Harry S. Truman. President Johnson credited President Truman with planting the seed of compassion and duty which had flowered into the care of the sick and serenity the fearful. End of quote. Implementation of the amendment required extensive data. Let me leave you with a quote from President Johnson. "We share," and I quote, "we share a care and a concern for the elderly, for the sick, and for the handicapped. We will not turn our backs on those who, through no fault of their own, can no longer sustain themselves. To us, the old, the sick, the hungry, and the helpless have represented not failure but human beings," end of quote. The nation will never again fall to the indifference. I know that a lot of you in this room are on Social Security, as I. So please, let's do the right thing today and pass this piece of legislation commemorating the 50th anniversary of the of the Medicare Act. And Mr. Speaker, I would like to overturn the ITL. I'd like to make a motion to overturn the ITL.
You would have to do that after the committee report was defeated, if that happens. At that point,
okay,
you could make that motion.
Thank you. Thank you very much.
You're welcome.
Chair recognizes the member from Hudson, Representative Russell Ober, to speak in favor of the committee report.
Thank you, Mr. Speaker. For those socialists among you, this is certainly a good deal. Would you like me to speak into the microphone? I'm not sure I want you to hear me. For you socialists in the audience, affordable health insurance, guaranteed. What does that mean? Who's going to pay for that? All of you are. Are you going to get anything from it? Not likely. I don't see any reason we should commemorate 50 years of giveaways. If we consider our governor, let me get that, Medicaid funds to guarantee health care. guarantee health care. Everybody gets it, whether you need it or not, and you're going to pay for it, whether you get it or not. Thank you.
This will be a division vote. Will members please take your seats? The House will come to order. The chair recognizes Representative Horrigan for parliamentary inquiry.
Thank you, Mr. Speaker, and thank you to my colleagues. If you know that Medicare and Medicaid are not necessarily perfect, but they're good programs that made a big difference to the life of the average Americans. If you know the 50th anniversary of the Medicare and Medicaid Act in 1965 is something that I think deserves to be celebrated by this House and by all Americans. Would you then overturn the ITL report by voting red so that an alternative motion can be introduced? Thanks.
The question is on the committee report on House Resolution 8. This is a division vote. If you are in favor, you will press the green button. If you are opposed, you will press the red button. The chair recognizes Representative Packard for parliamentary inquiry.
Thank you, Mr. Speaker. If I believe that there are many significant state and federal laws, thousands of them, some of which we may all agree with, some of which we may not agree with. And if I believe that the legislature should not be in the business of commemorating the anniversaries of all these state and federal laws, regardless of the subject matter, would I now press the green button and support the unanimous vote of the Legislative Administration Committee?
Question is on the committee report of ITL on House Resolution 8. This is a division vote. If you are in favor, you will press the green button. If you're opposed, you will press the red button. Voting stations will be open for 30 seconds. If all members voted who were present when the question was put, the House will attend to the state of the vote. There having been 255 members in favor, 71 in opposition, the committee report is adopted. The House will attend to the final bill removed from consent. So please stay in your seat. The Committee on Municipal and County Government, to which was referred House Bill 145, an act allowing municipalities to dedicate a percentage of timber yield taxes to the Conservation Fund. Having considered the same, report the same with the following resolution. Resolved that it is inexpedient to legislate Representative David A. Bickford for the committee. The chair recognizes the member from Hillsborough, Representative Porter, to speak to the committee report.
Thank you, Mr. Speaker, and I won't take long. Shades of the former representative from Manchester visited me. This bill should not have been on consent because the vote was 16-4. So I pulled it off consent. Please support the committee's report. Thank you.
Are you ready? Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it, and the committee report is adopted. We have all right. Before we do that, Chair is going to use his prerogative for a moment. You will note the time. You will note that we did something extraordinary today. We spent more time on bills removed from consent than we did on the regular calendar. I think that members need to, in none of those debates, there was nothing that came close to being overturned off consent. We are going to have some very, very, very long days if this continues in this manner. It cost us about $17,000 a day to call this House into session. The clerk and I will put together a calendar that should be easy for us to deal with and get out of here by 5 or 6 o'clock at night. However, if the House drags this on, we will be here in the coming days and weeks until whatever time it takes to complete our business, because the taxpayers should not have to suffer through paying additional monies for us to come back here. So I want you all to think about how we're proceeding and think about how we can be reasonable in doing the people's business. With that, we will attend. Next on the list is the House will now attend to H.R. 12, affirming revenue estimates which can be found in your seat pockets. The chair recognizes the member from Plastow, Representative Major, who moves ought to pass on H.R. 12 and is recognized to speak to his motion.
Thank you, Mr. Speaker. Representative Almy and Representative Major move to affirm the revenue estimates on House Resolution 12. And I'd like to speak to a motion.
You are recognized to speak. The House will be attentive.
Resolution 12 is a resolution that puts together the best revenue estimates that we have for the House. Since the 7th of January, the full committee has been working most of the time, 5 days a week, putting in many hours working these revenue estimates. We have brought in economists that would talk to us about the international economy, the national economy, the regional economy, the state economy, on housing, on labor, and other things, so that we could measure what effect what's going on around us will have on our revenues in New Hampshire. We also brought in the LBA and spent sufficient time to go over all the revenues and fees. Then we brought in all the agency heads and commissioners that had anything to do with revenues. We spent a long time on this, and we debated, and we come up with a unanimous vote on these resolutions. And then if you turn the page, the sum of the General Fund and Education Trust Fund. The first column is the official estimate that came out about 2 years ago, which is $2,219,800,000. And the actual that we're estimating for FY 2015 is $2,210,775,000, which is less than 0.5%. Our estimates for FY 16 is $2,240,375,000. It's been a long day, which is about a 1.3% above the FY 15 estimates. The estimate for FY17 is $2,261,700,000, which is about close to a 1% increase over the FY16. In addition, the highway funds total, which was estimated, and the official estimates was totaled out to be $246,900,000. Our estimate for 2015 is $246,800,000. For FY16, $228,800,000. FY17, $234,400,000. And the Fish and Game Fund, the official estimate about 2 years ago, $10,100,000. $11 million for the actual for FY15 we're estimating. FY16, $10,300,000, and FY17, $10,300,000. What we would like to do is have the House affirm these, and this is the first flush, so the Finance Committee can get to work, and this is the amount of revenue that they have to work with. We're going to re-look at these every month. March, April, May, and June, up to the point a committee conference is settled. Because this is very dynamic. The business taxes, the bulk of the business taxes come in March and April. The bulk of your interest and dividend taxes come in April. And they don't all come in linearly. Each month that we go by, we get a better idea of what it's going to really be. The Senate, when they get through their budget, is going to have an extra couple of months of revenues to make their projections on. So we are asking you to vote favorably, and then once you do, we ask you to table this so that we can move it off the table when we come back again month after month. Thank you.
The question is on the adoption of H.R. 12. Member may inquire.
Thank you, Mr. Speaker, and thank you for taking my question, if you would. We've looked at the docket. This bill on the docket was never in committee. There's no recorded vote. Now, obviously, under our rules, a committee may vote to present a resolution to the House, but if you look at the docket as it exists right now as I speak, there's no vote in committee to present this to us. Is that not correct?
The vote in the committee was unanimous, 18-0.
If I could...
Further question.
Further question. Thank you, Mr. Speaker.
Question, actually, I'll take this as a question of the chair rather than of the speaker.
Thank you, Mr. Speaker. If you'd address it as well. There's no vote recorded. We're looking at the docket now. There's no vote in committee. At best, this is before the House on a first reading.
Pursuant to House Rule 35C, the majority of the committee may introduce, and in fact they did vote to introduce this. So it was introduced yesterday in recess of the House, which is the purpose, one of the purposes for putting the House into recess, and this resolution was done. This is the normal and customary way that we do House resolutions on revenue estimates. It always has been in my 11 terms in the House. There is nothing that is introduced in the traditional way that a piece of legislation is introduced, because in fact these are the revenue estimates of the Ways and Means Committee, and there is nothing that could be introduced prior to the committee voting and developing those.
Further inquiry?
You may inquire.
Thank you, Mr. Speaker. Mr. Speaker, if the House committee voted on it, why is there no recorded evidence of that vote in the House records?
I am sure that that recorded vote exists in the committee file. It has not made it onto the internet or whatever you want to, however you want to refer it at this time. This is the customary and normal way that we have always proceeded with House resolutions on the budget.
Thank you, Mr. Speaker.
On the revenue estimates.
Thank you.
The question
If I may, the
May.
vote was 18-0 unanimous.
The question is on the adoption of House Resolution number 12. Are you ready for the question? All those in favor, say aye. Aye. Those opposed, nay. The ayes have it, and the estimates are adopted. Chair recognizes Representative Major for a motion.
Mr. Chairman, I move that we table H.R. 12.
The question is on
Mr. Speaker.
on tabling of H.R. 12. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it, and House Resolution 12 is laid upon the table. The chair recognizes the member from Brookline, Representative Flanagan, for the third reading motion.
When you have the budget memorized. Resolved that the House now adjourns from the early session, that the business of the late session be in order at this present time, that the reading of bills be by title only and resolutions by caption only, and that all bills ordered in the third reading be read a third time by this resolution, and that all titles of bills be the same as adopted, and that they be passed at the present time, and when the House adjourns today, it will meet on Thursday, February 12th at 1 p.m. for the budget.
Question is on the third reading motion. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it, and the motion is adopted. Members, would you please stay in your seats? We do have unanimous consent request followed by announcements. And particularly relative to executive sessions, there are chairmen who would like to get a couple of bills voted out today. Representatives Alisea and Roberts request unanimous consent for the purpose of speaking to Black History Month.
Thank you, Mr. Speaker. Sometimes my voice goes out, so please bear with me. In 1718, New Hampshire barred all Negroes and Indians from serving in the militia. With the passage of the New Hampshire Militia Law of 1776, that exclusion was expanded to include mulattoes. It wasn't until 1777 that Negroes were allowed to serve. However, they had to be slaves substituting for white militiamen. Any slave accepted into a New Hampshire regiment was purchased by the state of New Hampshire and was granted its freedom. In 1775, the Massachusetts Committee of Safety stated that all such freemen could join the army assembling near Boston, but that no slave be admitted whatsoever. As the colony forces assembled outside Boston, dozens of free men from New England colonies with their fellow white colonies prepared to risk their lives in the impending Battle of Bunker Hill. New Hampshire militia law did not prevent Jude Hall, a free man from Exeter, New Hampshire, from risking his life at Bunker Hill. Jude Hall, with other free men, black men, willingly risked their lives fighting for the same freedoms and rights that took almost 200 years for the descendants to enjoy. I wonder how many New Hampshire free men and women were lost to history because they had been barred by law from proudly serving under the colors of New Hampshire. On a cold, rainy night back in 1842, pro-slavery Senator Moses Norris Jr., on his way home, came across a hungry black man who had been refused shelter in a nearby hotel, sitting on a gravestone in Pittsfield, New Hampshire. Despite his views on slavery, Senator Norris took him to his home so the black man could be fed and have a place to spend the night. Upon entering his home, the black man was greeted with disdain by Mrs. Norris and was repeatedly called the N-word by the children. This pro-slavery senator, for some reason known only to him, may have changed the course of American history. This black man, a former slave, a son of a white man, and a black slave, was to visit New Hampshire twice more to include speaking at the 100-seat Portsmouth Lyceum. I once knew a little colored boy whose mother and father died when he was but 6 years old. He was a slave and had no one to care for him. He slept on the dirt floor in a hotel, and in cold weather would crawl into a meal bag head foremost and leave his feet in the ashes to keep them warm. Often he would roast an ear of corn and eat it to satisfy his hunger. And many times he had crawled under the barn or stable and secured eggs, which he would roast at the fire and eat. That boy did not wear pantaloons as you do, but a tall linen shirt. Schools were unknown to him, and he learned to speak from the old Webster spelling book and to read and write from posters on cellars and barn doors. While boys and men would help him, he would then preach, speak, and soon become well known. He became a presidential elector, a United States Marshal, a United States Recorder, and finally a United States diplomat, and accumulated some wealth. He wore broadcloth and didn't have to divide crumbs with the dogs under the table. That boy was Frederick Douglass. What was possible for me is possible for you. Don't think because you are colored you can't accomplish anything. Strive earnestly to add to your knowledge, so as long as you remain in ignorance, so long as you will fail to command the respect of your fellow man. For people who question the need for Black History Month, today we first acknowledge not only the mistakes made by the General Court and the people of New Hampshire, but also acknowledge the action by the people of New Hampshire to rectify those mistakes. But even more important, as a fatherless, mixed-race child living on welfare with a mother with a 9th grade education and 6 younger siblings, I needed heroes who looked like me. When he said those words, or said these words, what was possible for me is possible for you. Don't think because you're colored you can't accomplish anything. Strive earnestly to add to your knowledge. I had my hero, and my life was forever changed. Just like Senator Norris, one single act can possibly change the course of a life and possibly the course of American history. Judith Hall and Frederick Douglass may have been Black heroes, but they were New Hampshire and American heroes. That is why we have Black History Month, not just for African Americans, but for all Americans.
Mr. Speaker, honorable colleagues, State House staff, and guests in the gallery. I have lived in New Hampshire for 46 years, and as many of you have, I've witnessed our beloved state become more and more diverse. Though I would like to tell you my story, I will not take the House's time to do so. What I will share is that, like everyone in this room, I would not be where I am today if it were not for people who fought and lost their lives to make things better for the next generation. I truly salute those persons that put their lives on the line, those persons whose shoulders I now proudly stand on. Differences bring us together. Likenesses keep us together. And the work that we do today will bring us forward to tomorrow. February is designated as Black History Month. Dr. Martin Luther King Jr.'s speech, I Have a Dream gave many people of all faiths, races, ethnicities, and cultures a voice of hope. I was one of those persons, and that is why today I can comfortably stand in front of you and share that my hope is to advance the dream. I would like to take a moment and read a poem written by one of my favorite authors, Khalil Gibran, titled The Prophet. Your children are not your children. They are the sons and daughters of life's longing for itself. They come through you, but not from you. And though they are with you, yet they belong not to you. You may give them your love, but not your thoughts, for they have their own thoughts. You may house their bodies, but not their souls, for their souls dwell in the house of tomorrow, which you cannot visit, not even in your dreams. You may strive to be like them, but seek not to make them like you, for life goes not backward, nor tarries with yesterday. You are the bows from which your children, as living arrows, are sent forth. The archer sees the mark upon the path of the infinite, and he bends you with his might, that his arrows may go swift and far. Let your bending in the archer's hand be for gladness, for even as he loves the arrow that flies, so he loves also the bow that is stable. The word diversity is a noun. It means variety, a point of difference, and likeness. Again, I say that differences bring us together, as likeness keeps us together. The work that we do here today will bring us forward to tomorrow. I would ask you to honor our future generations and advance the dream. It doesn't take much. Ask yourself at the end of the day, did I very eagerly respect or service an individual today or yesterday? DIVERSITY. Diversity. Thank you.
Chair recognizes Representative Sherwood.
Thank you, Mr. Speaker. Mr. Speaker, I would move that the remarks of the gentleman from Keene and the gentlewoman from Bosquen be placed in the permanent journal.
Motion is to place the remarks of the previous speakers in the permanent journal. Are you ready for the question? All those in favor, say aye. Aye. Those opposed, nay. The ayes have it, and the remarks will be placed in the journal. Representative Itzy requests unanimous consent to speak to the form of government. And please stay, we have many announcements.
Thank you, Mr. Speaker. I don't come down here lightly, and not without the advice of my colleagues. But last week, we were told that our form of government had evolved, that an enumerated right of the people had been allowed to legitimately fall by the wayside. And I feel compelled to address that. I've been doing some really interesting reading this summer and fall. I've been reading John Locke's second treatise on government, and I found some interesting things. Article 1, all government of right is founded in consent. Article 2, all men have certain natural, essential, and inherent rights. When men enter into a state of society, they surrender up certain of their natural rights for the protection of others. Without the protection, the surrender is void. Article 4, among natural rights, some are by their very nature unalienable because no equivalent can be given or received for them of this sort of rights of conscience. Article 7, the people of this state have the sole and exclusive right of governing themselves as a free, sovereign, and independent state. Article 8, all power originates in and is derived from the people. Article 10, whenever the ends of government are perverted and the public liberty manifestly endangered, and all their means of redress are ineffectual, the people may and of a right ought to reform the old or establish a new government. Article 12, every member of the community has a right to be protected in the enjoyment of their life, liberty, and property. He is therefore bound to contribute his share to the expense of such protection and his personal service when necessary. Why do I read these to you? These are all paraphrases of Locke. They establish in our Constitution a pedigree of Lockean social contract. Locke also states some other very interesting things, and I quote, "The great end of man's entering into society, being the enjoyment of their properties in peace and safety, the great instrument and means of that being the laws established in that society, and the first and fundamental positive law of all commonwealths is the establishing of the legislative power, as is the first and fundamental natural law, which is to govern even the legislature itself, is the preservation of the society, and as far as will consist of the public good of every person in it. This legislative is not only the supreme power of the Commonwealth, but sacred and unalterable in the hands where the community have once placed it." To paraphrase, the legislative power is supreme in government. And again, though a constituted commonwealth standing in its own basis and acting on its own nature, that is, acting for the preservation of the community, there can be but one supreme power, which is the legislative, to which all the rest are and must be subordinate. Part 1, Articles 28 and 29, and Part 2 cement this legislative body and the Senate as the supreme legislative powers in this state, the General Court. Now, it was correctly stated that once we did have a very parliamentary form of government. The chief executive, the president, was the president of the Senate and a voting senator. The executive council was comprised of 3 representatives and 2 senators elected by the General Court in joint session. And as we still do, the Treasurer and Secretary of State were elected by the General Court in joint session. And the legislature created all of the judicial courts. But these characteristics didn't just evolve over time. Over time, the people amended the Constitution and intentionally changed their form of government. They distanced the executive and the judicial branches from the legislature. In 1792, the governor was no longer the president of the Senate, and the executive council was directly elected. In 1966, the Supreme and Superior Courts are no longer legislative. And in 1978, the Supreme Court can promulgate rules with the force of law, independent of the legislature. But what is the effect of these changes? Relative to the legislature, do these elevate the other branches, making them co-equal, or do they lower them? To quote Locke, now you must understand, in Locke's perspective, the practice of the time, the judiciary was a subset of the executive, so he doesn't discuss the judiciary directly at all. Quote, "The executive power placed anywhere but in a person who also has a share of the legislative is visibly subordinate and accountable to it." To put it simply, the more distant you make the other branches of government from the legislature, the weaker they become. Now let us look at redress of grievances. It is suggested that that duty has been gradually transferred to another branch of government. But if Article 1 is true, consent of the governed, if Article 8 is a fact, that the power is derived from the people, is that transfer legitimate without an amendment? Is it our prerogative to suspend or delegate an enumerated right of the people without their express consent? Can we deny their right unless they surrender it? Remember that one of the enumerated indictments against King George was, quote, "We have petitioned for redress in the most humble terms, and our repeated petitions have been answered only by repeated injury. Do we expect in the end the people of New Hampshire will be any more generous with us than they were with King George?" Why do we have a constitution in the first place? because our founders had experienced that without a written social contract, independent of the legislative power, that their constitutional rights and privileges were as dependable as the shifting sands of a desert. What good does it do to take an oath to uphold the Constitution if we allow it to be subverted, or worse, subverted ourselves? Remember that actions speak louder than words. What does it say of us if we, as the fiduciaries of the people's power, a Lockean phrase, if we allow the other branches of government or we ourselves amend that written social contract with unwritten words and without the people's consent? In my opinion, we are no better than thieves or brigands, and we deserve to be treated as such. May God save the great state of New Hampshire and her sovereigns, the people of the state.
House will be in order. Chair recognizes Representative Fred Rice for purpose of making brief remarks on flag etiquette.
Thank you, Mr. Speaker. Every morning when we assemble here in the House every Wednesday morning, a couple of the first things that we do is we recite the Pledge of Allegiance to the flag, and we sing the national anthem or have it sung to us. Altogether too often I have noticed people who don't really know what you're supposed to do when those two things happen. Flag etiquette, according to the Flag Code, says that when either the Star-Spangled Banner is sung or rendered, or the Pledge of Allegiance is recited, we should stand with our right hand across our heart. I have observed in this House on more than a few occasions people who have not. They either stand here like this, or they have their hands in their pockets, or their hands are crossed, or whatever. I would ask that you observe that. This is the flag of the United States of America. It represents our republic. The other item, a couple of years ago, the United States Congress passed a law that authorized all veterans to salute in lieu of this, to render a hand salute when the Pledge of Allegiance was recited or the Star-Spangled Banner was played or sung. Again, I would ask that everybody do this. Now, when I brought this up 2 terms ago, Representative Baldessaro let me know in no uncertain terms that the Marine Corps doesn't salute when they're uncovered and indoors. I understand that, and I respect that. If that's a service custom, then it should be respected. However, for all those who served in the rest of the armed forces instead of the Marines, my thanks. I got to rag on Representative Baldessaro. But I would request that you do pay attention to that, not only here in the House, but elsewhere where you go. Be proud of your service. Stand there, render the hand salute during both the Star-Spangled Banner and the Pledge of Allegiance, and let people know that you were one of those who did serve. Thank you.
Was the remark? House will be attentive to announcements. Representative Hinch, followed by Representative Elliott.
Thank you, Mr. Speaker. This announcement is for the Legislative Administration Committee. We will meet in executive session in room 104 LOB 15 minutes after the close of the session today for the purpose of execing HJR 1FN and HR 9. Secondarily, to those vice chairs and chairs who have not received your number plates yet, there are more number plates that have come in. If you'd go upstairs and see Sandy, you may find that yours are there. Thank you.
Representative Elliott, followed by Representative Katowski.
In your mailbox this morning, you all got this flyer because we'll be over here after the breakfast is over next Wednesday. So this is the first time that I know of that this has ever been done. It's an ecumenical service for the House of Representatives and the Senate is to be the guests of the Council of Churches for Concord, New Hampshire. So I hope all of you will plan to attend. It starts next door at 7:30 a.m. and we've got some distinguished visitors there. We don't have one bishop, but we have two bishops conducting the service, and all of the other higher officials from all of the churches in the city of Concord. It will also be the beginning of Ash Wednesday. It will be a time of ashes and penance and forgiveness for all those state reps who voted the wrong way on today's bills. So I think you should be there and do penance. However, I would like a show of hands. Do you have any idea how many would be there? Just raise your right hand. Have already thought about it? 1, 2, 3, 4, 5, 6. Okay, well, Jesus said where 2 or 3 are gathered together, that's enough.
Representative Katowski, followed by Representative Burt.
Thank you, Mr. Speaker. This is not an echo. Health and Human Services will meet in room 205 to exec 2 bills 15 minutes after the close of this session.
Representative Burt, followed by Representative Belanger.
Thank you, Mr. Speaker. I do apologize for the last time I was up here about my announcement at SIG Arms. I did see a lot of faces and a lot of people spoke to me after. They were all excited that I was standing here because they thought I was going to bring up Hot Dog Day. But I will tell you, the date has been picked, June 3rd. So make sure you put it in your calendar. But the reason I am before you, and sadly a very few of you, is Monday, February 16th at 12:45. I still have a very little bit of room. Please come over to SIG Arms, but you have to let me know. SIG Arms Academy, and it's 233 Exeter Road in Epping, New Hampshire, and we will be shooting guns with suppressors and shooting guns without suppressors, so you understand what a suppressor does. Because there's a lot of myths out there, especially in the movie land. They think that they're silent and they are not. So please check the House calendar and let me know by Friday, if you could, Saturday the latest, because they do need a head count. And again, that is this coming Monday, President's Day, because we have it off and you guys have nothing else to do, so please join me Monday in Epping. Thank you, Mr. Speaker.
Representative Belanger, followed by Representative Rowe.
Thank you, Mr. Speaker. If you haven't already gone home, municipal and county government will exec House Bill 235 and House Bill 407, LOB 301, as soon as the last gavel falls.
Representative Rowe, followed by Representative Ladd.
The Judiciary Committee will meet for cocktails and exec in 15 minutes after we end. Oh, that's wrong. Tomorrow we're going to hopefully exec the bills that are in the calendar. Plus we're going to look at House Bills 292, 203, 151, 417, and 315.
Representative Ladd, followed by Representative Hosel.
Thank you very much, Mr. Speaker. In addition to bills on the calendar for tomorrow, we will meet, the Education Committee will meet at 11:15 in executive session to discuss HB 562FN. That's the adequacy bill that we have here in the House. So tomorrow at 11:15 we will hear that bill. Thank you. Or exec that bill.
Representative Hosel, followed by Representative Christie.
Thank you, Mr. Speaker. I have 2 announcements for the Rockingham County Subcommittee on Categorical Assistance. We'll meet right over here under the clock in Reps Hall immediately following this session. we need to take action on our recommendation for the budget. Secondly, in addition to the exec bills that we have on the calendar for tomorrow morning at 10 a.m., we will also exec on House Bill 659, House Bill 652, House Bill 185, House Bill 149, House Bill 204, House Bill 328, and House Bill 127. That's will total 14 bills that will, election law, I'm sorry.
Representative Christie, followed by Representative Callie Pitts.
Thank you, Mr. Speaker. The House ED&A Committee will meet in executive session right after we leave here today to exec the following bills: House Bill 401, House Bill 468, House Bill 602, House Bill 674, and House Bill 682. And if we don't finish them this afternoon, we'll do it at 10 o'clock tomorrow morning. Thank you.
Representative Callie Pitts, followed by Representative Hunt.
If anybody's here from the Rockingham Sheriff's Committee, I have not canceled the meeting for Friday. I'm hoping the snow gods smile on us, but I have brought the budget to you, and it is in your mailbox. Thank you.
Representative Hunt, followed by Representative Kidder.
Thank you very much, Mr. Speaker. The Commerce Committee will not meet this afternoon. Instead, I want you all to go over to Delta Dental, which is 4 o'clock, and they do put on a good spread. So everyone is invited to Delta Dental.
Representative Kidder, followed by Representative Chandler.
Thank you, Mr. Speaker. The Fish and Game Committee will meet tomorrow morning in 307 at 9 o'clock, and we have 3 bills, early bills left to exec: 518, 663, and 354. So see you tomorrow morning. Thank you.
Representative Chandler, followed by Representative Intron.
I think Representative Hunt mentioned this, but I will say, as a self-appointed Commissioner of Fun and Festivities, I would announce the Delta Dental event. The address is in your calendar. We had thought we were getting out earlier, so we called them, and they were prepared for us to come earlier, actually. But for those of you that can make it, the rest of you all go to executive session meetings, and more shrimp for me.
Representative Intron, followed by no one. Oh, except the clerk.
Thank you, Mr. Speaker. To the members of Science, Technology, and Energy, I hope you're still around. We'll meet right now in room 304 of the LOB to exec the following bills: 209, 207, 360, 345, 342, 352, 252. Thank you.
And with apologies, the clerk did have a notation. He had an announcement.
Thank you, Mr. Speaker. Just a quick announcement. If you are not planning on being here, tomorrow is a session day. It is the governor's request at 1 o'clock, governor's budget request at 1 o'clock. If you are not going to be here, please let us know so that we will list you accordingly as excused for the day. Also, tomorrow is the deadline for reporting early bills. So those of you who are on committees that have early bills, please make sure you make every attempt to get here and work with your committee and get those over to us so that next week we can have a nice, fun-filled, and packed calendar. Thank you.
Representative Shurtleff moves that the House stand in recess for the purpose of the introduction of bills and receiving Senate messages. Are you ready for the question? All those in favor say aye. Aye. Those opposed, nay. The ayes have it and the motion is adopted. The House is in recess until Thursday, February 12th, 2015 at 1 p.m. Please push your buttons to register for mileage.